Hello viewers, I am Dr. Ankit Shrivastava, Assistant Professor of Law at Rajiv Gandhi National University of Law, Punjab. I am here today with another chapter in the course of Law of Torts 1, and today we will be discussing about the limitations of personal capacity to sue and be sued. The English common law paved the way for the development of tort law. The French term tort comes from the Latin term tortum, which means twisted or crooked. The term signifies a departure from conventional, decent, or polite manners. It is the English equivalent to the phrase wrong. A tort is an act of misconduct, whether performed or not, that causes harm to another person. The victim then sues in civil court, seeking all legal remedies, including unliquidated damages, an injunction, and return of lost property. Unliquidated damages relate to the amount of damages that the court must decide or demonstrate. Under tort law, anyone can file a claim and be sued. However, keep in mind that this is a broad guideline that can be changed to apply to specific group of people. When someone is hurt in a tort, they frequently have the right to sue the person who did the harm. Although some people fall into specific categories, while others cannot be sued at all. When someone's legal rights are violated, they file a suit in the court as the plaintiff. The defendant in this case is legally accountable for infringing the plaintiff's rights. Now, everyone has the ability to sue and be sued in tort is the standard. However, this generalization is not always true. To join a lawsuit, a person must have the appropriate legal capacity. Some people are not fully protected by the law in terms of civil and social rights. This is known as non sui juris. Because children are not sui juris, when under the age of majority, the law is intended to protect them from their own negligence. A person with a legal disability is a minor who is under the age of majority. The law typically allows any rational person, including business people, organizations, the government, and other individuals, to initiate a lawsuit as long as they are of sound mind and are not otherwise prohibited by law. Now let's move on to the next topic and let's discuss the capacity to sue and be sued in torts. The locus standi tradition serves as the foundation for the fundamental rule that only those who have suffered legal damages are entitled to judicial recourse. Based on the idea that only an individual whose rights are in danger is qualified to pursue a remedy, this rule gives rise to the following legal proposition. The first, only he has legal redress in the area where his own legal rights as to person or property are gravely and explicitly violated. Second, a person who suffers along with other members of the public as a result of an administrative action cannot contest the action in question unless he can show some specific injury to himself that is above and beyond what other people have experienced. The court will often not consider a petition filed by a complete stranger who is contesting an administrative action. Previously, a person could only initiate a lawsuit in order to obtain judicial remedy if they had suffered specific legal loss as a result of an actual or threatened violation of a legally protected right or interest. However, this standard is very old, having originated at a time when private law dominated the legal system and public law was non-existent. The fundamental tenet of tort law is that everyone is both entitled to sue and susceptible to being sued. This rule is not unbreakable though. Due to unique laws and circumstances, there are deviations from this fundamental standard resulting from individual disabilities. Certain individuals are not eligible to file or be granted a tort suit. So let's now discuss that who can sue. Now there are 7 categories of people who cannot be sued subject to certain limitations: an alien enemy, convict, bankrupt, husband and wife, corporation, an infant or minor, and a foreign state. So now let's discuss these one by one. The first one is an alien enemy. A person who resides in hostile territory or has an enemy nationality is considered an alien adversary. Such an individual is not entitled to file a tort lawsuit. English law states that a person's ability to sue cannot be maintained unless authorized by an order in council. In accordance with Indian law, a person cannot continue to pursue legal action without first obtaining central government approval in accordance with section 83 of the Civil Procedure Code. Let's take an illustration. A cannot file a lawsuit against B, an Indian resident, without the central government's approval if he lives in or is a citizen of a hostile nation. Now the second is convict. A convict is a person who has a court decree imposing death or imprisonment upon them. Under English law, a person whose sentence has not yet ended is not allowed to file a lawsuit for any kind of recovery or property loss. However, this concept was dropped by the 1948 Criminal Justice Act. In India, a property forfeiture offence up until 1921 precluded the offender from suing for any harm. On the other hand, an Indian prisoner is now able to sue for both physical and property injuries. Let's see some illustrations. First situation. Prior to 1921, if A was convicted of a crime and wanted to sue B for property related harm, he could not do so since B had committed the crime of forfeiture of property. And scenario 2. Now following the 1921 amendments to the Indian Penal Code, an incarcerated individual named A may file a lawsuit against B for harm to his body or property, and he may do so for both types of injuries. Moving on to the third, that is bankrupt. Additionally, a bankrupt person is not permitted to sue for any property damage. All of his assets are vested in the trustee under the English law, while under the Indian law, the bank or official assignee is the legal owner of all of his assets. For any offences against the property, the trustee or assignee may file a lawsuit. However, if they feel that they have been wronged personally, they have the right to sue. If a tort affects a person as well as property, the parties' rights of action will be shared between them. Let's see an illustration. Situation 1, that if A is bankrupt and his property is vested in the possession of the official assignee, that is C, by the bank, if B trespasses on his property, the right of action is vested in the official assignee, that is C. Now let's see the situation number 2. If B trespasses A's body, then in that situation the right of action is vested with A itself. The fourth point is husband and wife. In Old English law, a husband and wife could not file a lawsuit. A wife can sue her husband under the Married Women's Property 1882. However, the spouse is unable to sue his spouse. A wife could not bring a personal injury or antenuptial tort lawsuit against her husband. A significant shift was made in 1962 when the Law Reform Husband and Wife Act was passed, allowing both parties to file a lawsuit. Now in India, a spouse may file a lawsuit for any offence. Moving on to the next point, that is corporation. Given its very nature, which precludes it from suffering personal injury, a company cannot bring a lawsuit for personal injury. However, it may do so for torts pertaining to its property. The qualification is, first, that the tort must not be impossible in nature, and the second is that in the case of defamation, the corporation can sue the other person if it can prove that the injury has the tendency to cause actual damages. And the third is that a corporation may sue for libel or any other wrong affecting its property or business. Now, in the case of Manchester versus Williams, the court held that a corporation has a right to sue not only for the property but also for its personal reputation. The next point is an infant or a minor. Now, a minor may file a lawsuit for the tort done to him subject to the approval of his guardian or nearest friend. However, he is unable to sustain treatment for the harm he suffered while still inside his mother's womb. In Walker versus Great Northern Railway, a pregnant woman was hurt in a train accident which caused her unborn child to be malformed. The kid cannot pursue a remedy for the harm he suffered while still inside his mother. That was the ruling of the court. However, in a case with the same facts, the Canadian Supreme Court granted the child's remedy. The next is a foreign state. Now, without Her Majesty's consent, or such in case without His Majesty's consent, no action against a foreign state may be filed in any English court. If a foreign state has been recognized by the central government, it is allowed to file a lawsuit in India under section 84 of the Civil Procedure Code. Now, moving on to the next topic, let's discuss who cannot be sued. Any reasonable person, such as a businessman or organization, may be held liable for actions taken by them or their employee while they are working for them. Now, who cannot be sued? There are few categories of people who cannot be sued, like the government, foreign sovereign, ambassadors, public officials, infants or minor, lunatic, the corporation, trade union, married women. Now, let's see these aspects also one by one. The first one being is the government. Now, under Article 361 of the Indian Constitution, the President, Governor and Raj Pramukhs of the state are not answerable to the court for exercise and performance of the power and duties of their office. Second, for any act done by them in the exercise of their powers and duties. Now, there are 5 rules regarding the liability of the government. The first one is, when a private individual engages in a transaction, the government is accountable for the actions of its employees. Second, the government bears responsibility for the harm brought about by the forest officers' inappropriate intervention during the plaintiff's timber removal, as the plaintiff had acquired a forest. Third, A lawsuit about an act committed by a servant while the government was exercising its sovereign rights is not admissible. For example, actions taken during riots, during wartime, or when using territory for bombing drills. Let's see an illustration. So, if a policeman A orders a lathi charge during the riots, Z is injured and sues A. In this case, A is not accountable because he is acting in the capacity of a sovereign power. The fourth point is accountable for returning any money or property that its agent improperly took on its behalf. Illustration. So, if a government employee, wrongfully returns B's property on the government's behalf, in this case, the government is responsible for restoring the land. The fifth is, unless specifically authorized, the government bears no liability if an act is carried out by an employee while they are performing their duties. Let's see a case of Kasturi Lal versus State of Uttar Pradesh. Since police officers are government employees in India, the plaintiff filed a lawsuit against the government in this case after the police officer took the petitioner's gold and lost possession of it. The court decided that the government is not responsible for anything a government employee does while carrying out his or her duties unless the employee is expressly authorized to do so. In the event that a servant commits a tort, the government may be liable in one of the two possible ways. The first one is, it is not possible to sue the state for damages if the servant acts within the bounds of its sovereign power. And second, however, if the conduct is carried out in the performance of the function that he has been assigned rather than by virtue of the delegation of sovereign power, a damages case would arise. Let's see a case law of Union of India versus Shugrabai. Once, B was hit by a military driver from the artillery school who was tasked with moving the machine. As a result, B passed away. Given that he was given the task and that the action was taken while doing his duties, the government is accountable in this case. The next point is foreign sovereign. If a foreign sovereign does not give the local government a license to operate, they cannot be sued. Residency abroad does not revoke an individual's entitlement to local government representation. A foreign sovereign may only be sued in an Indian court under the civil procedure statutes with permission from the national government. The conditions under which the central government gives permission are, the first one is that if the foreign sovereign has instituted a suit in court against the applicant, and second, if the foreign sovereign by himself or by an agent trades within the local limits of the Indian court. And the third is if the foreign sovereign's immovable property in respect of which the applicant wants to sue is situated in India. Under section 86 and 87 of the CPC, a foreign sovereign may be sued without the central government's consent if the plaintiff is the foreign sovereign's tenant and the claim relates to territory he owns. In all other cases, the central government's consent is required, and once the permission has been requested and denied by the government, the court cannot contest the legitimacy of the decision to withhold authorization. Let's see an illustration. So, A wishes to take foreign sovereign B to court. He can only file a suit with the central government's approval. Moving on to the next point, that is ambassadors. So, foreign ambassadors, their families and their servants cannot be sued unless they have given up their privilege and acknowledged the court's jurisdiction. Lawyers cannot be brought against ambassadors while they are serving in office. Legal actions against foreign ambassadors in India can only be brought in court with the national government's consent. There is a very famous case of Harbhajan Singh Dhalla versus Union of India. In this matter, the petitioner kept up the Algerian embassy's upkeep as well as its renovations and repairs in New Delhi. He petitioned the Ministry of External Affairs for authorization to sue the Algerian embassy after his attempt to collect his debt was unsuccessful. Apart from asserting that the petitioner had not presented reasonable and convincing evidence as per section 86, the ministry refused to grant the license, citing political grounds. Furthermore, if permission has been asked for and turned down, the court is unable to review the government's decision to refuse consent. Next is public official. Regarding the torts that the public official has committed, no action is pending against them in their official position. However, they could face legal action for the private conduct they engaged in. No action can be taken against the government if a government servant acts in the exercise of their sovereign authority. In the case of Union of India versus Bhagwati Prasad, the taxi and the train collided. Now, Bhagwati Prasad accuses the Union of India of negligence in relation to them. It was decided that a lawsuit seeking damages might be brought against an official acting in their personal capacity, but not against an official acting in their capacity as a sovereign. The next is infants or minor. A lawsuit may be filed against the child or minor for the adult performed act. Hence, a minor may be sued for crimes such as assault, false imprisonment, libel, slander, fraud, etc. But if the minor's intent, awareness, or other mental state is a necessary component of the offence, the minor or infant may be released from accountability because of their mental incompetence. In Wamsley versus Humanic, two young boys engaged in activities pertaining to cowboys. When the arrow was shot by one boy, it struck the eye of another boy. A 5-year-old youngster doesn't even consider it. Therefore, the court rules in the defendant's favor. As a result, the defendant was exempted. The next is lunatic. There are two conditions related to lunatic. One, that if an insane person committed the conduct while not in a state of stable mind, they are not eligible to be sued. As an example, suppose A beats B when he is not mentally competent, it is not possible to sue him. Second, however, a madman may be sued if the deed was committed while he was still of sound mind. Example, let's say A has a sickness that causes him to go insane for a while before returning to normalcy. In the event that in his usual state he assaults B, it is possible to sue A in that case. Moving on to the next point of corporation. A corporation is immune from lawsuits unless the action was taken while acting as an agent for the corporation, or second, the action taken was appropriate given the corporation's goals. So, in the case of Polton versus London and SW Railway Company, the defendant company's railway master detained a man who failed to pay the freight cost for the horse he was transporting. A lawsuit was brought by the petitioner against the company. It was decided that the railway master's job was to arrest the person solely in the event that he failed to pay his own freight. He was not granted the authority to make an arrest if someone did not pay the freight for the items he was carrying. Since he is operating in his individual role here, the station master alone may be held accountable rather than the whole business. The next is trade union. Under the Trade Union Act of 1926, it prohibits lawsuits against registered trade unions in India. But as a result of 1939 amendments to the Act, a labor union can now be sued using its registered name. Let's see an illustration. In the event that an XYZ trade union member commits a tort, then there arises some situations. The first one is that XYZ cannot be sued because of the Trade Union Act of 1926. And in the situation number 2, XYZ may be sued following the modifications or amendments in the year 1939. So friends, to conclude, an individual who sustains an injury possesses the legal entitlement to initiate legal proceeding against the individual responsible for causing harm. However, there exist specific groups of individuals who are exempt from filing a lawsuit for their damages. Additionally, there are certain individuals who are immune from being sued by anyone, such as foreign ambassadors, public officials, infants, sovereigns, and alien enemies. However, there are specific restrictions on when these group of individuals can file lawsuits or be sued. These limitations are contingent upon the approval of the central government and until they voluntarily give up their special rights by submitting to the court's authority. With this, we come to the end of our today's lecture. Thank you very much.